On March 1st, 2026, in Bell County, Texas, a family court judge presided over a child support modification case that would test the boundaries between informal evidence and legal proof. The case, styled in the interest of Hoag Lewis Matterchild, involved a father seeking to reduce his monthly child support obligation from $304 to approximately $206 following a workplace injury that allegedly diminished his earning capacity. The custodial mother objected, claiming she had discovered evidence of substantial unreported income from the father's carpentry side business, a dispute that would force the court to grapple with what actually constitutes admissible evidence in family law proceedings.
So at this time, court's going to go ahead and call Bell County calls number 260,845. This is in the interest of Hoag Lewis Matterchild. Court will know for the record. This matter's had several things over the last couple of years going on in it. The court will know for the record that in 2024, it appears the court did an order enforcing, and then in 2025, an order suspending commitment as that to that enforcement as it applied to Mr. I guess that'd be Mr. Lewis. Anyway, the court will note for the record that this is before the court to enter order today. The court, there was a modification in this case at one time that I'm looking at, looks like it may have been bifurcated from the enforcement cause of action, but those orders are all final as far as this court's concerned. And I asked the state for an opening to tell the court what the state's requesting we do here today. My understanding is that Ms. Hogan, we had some reservations about the entry of an order in this case. And I want you to confirm that it's the entry of order on the modification, because like I said, it looks like the enforcement portion.
Your Honor, that is correct. This case is only focused on a modification of child support based on a workplace injury and a subsequent some reduced Mr. Lewis's earning capacity. There was a downward modification of his child support of approximately $100. He was paying approximately $304, and then based on this mod, he would be paying on the order proposed $206, and then he's still paying $72 in cash medical support. I believe the issue is most likely just simply the fact that of the reduction in the child support obligation. I'm not aware of any technical or material problems or concerns with the order itself. I'll let the party explain herself, but based on our review of the records and review of the court's ruling, this order has been prepared in compliance and in conformity with the court's rule. So we'd ask that it be granted as is, and that's all we've got.
All right, Ms. Hoag, the state's asking me to go ahead and enter this order that modifies the child support. The enforcement stuff has already been taken care of, and already all final. Is the state's understanding that you have some objections or some reservations of the court order as far as the lowering of the modifying the child support downward by approximately $100? So at this time, ma'am, on the record, the state's asking me to go ahead and sign off on that order, doing that, lowering that modification. Is there a legal reason, ma'am, why I should not? And if there's any reason why I should not, I need for you to tell the court at this point. Thank you, ma'am.
Yes, so I have evidence of Eric making way more than what he's reporting. And I don't know what injury he's talking of, but I do have evidence of him.
All right, here's the deal, ma'am. What you may consider evidence and what I can may consider evidence may be a little different. So at this time, let me go ahead and ask you to raise your right hand and unmute yourself and turn on the video and raise your right hand. And let me get you under oath, and you can tell the court what you understand that information is. All right, ma'am, raise your right hand. Do you solemnly swear or affirm your testimony you're going to give here today is the truth, the whole truth, and nothing but the truth so help you?
Yes.
All right, ma'am, you can put your hand down and tell the court what you understand. What I know you're not a lawyer, so what proof do you have, or what do you understand the proof is that the father is intentionally underreporting his income information?
Yeah, so I have pictures of him doing work from his social media and reporting those pictures and things like that of prices and everything.
Okay. And ma'am, what's your understanding of what is he doing for the earned funds?
So he is building things out of wood, whether anything that you want, a patio out of wood, he's building furniture out of wood. What is it? Carpentry, I think that's what it's called. Um he anything out of wood he can make. Shoe boxes, furniture, patios, and I have evidence.
All right, then.
The custodial mother attempted to block a child support reduction by presenting social media photographs showing the father's carpentry work, which she believed proved he was earning unreported income. The judge immediately recognized a critical distinction between what a layperson considers evidence and what a court can legally consider proof. Under the Texas Family Code Section 154062, child support calculations must be based on net resources, defined to include all wage and salary income, self-employment income, and any other compensation received. However, Section 154066 provides that when a court finds a parent is intentionally unemployed or underemployed, it may apply the parent's earning potential rather than actual earnings. The burden of proving intentional underemployment falls on the party challenging the income determination, and Texas courts have consistently held that mere suspicion or unverified claims are insufficient. Courts require concrete evidence of actual earnings or deliberate income suppression, as established in INRI PC's 2015 WL 4938919 Tex App. Houston 14th Dist, 2 others Vin 15, where the court refused to impute higher income without proof of actual wages received. Mims Holton's social media photographs, while suggestive of work activity, failed to establish the critical element of actual income received. The judge's decision to place her under oath was procedurally necessary, Texas Rule of Civil Procedure. 8.3 requires sworn testimony for evidence to be considered in contested hearings, but even sworn testimony about photographs cannot transform speculative conclusions into proven income. Without bank records, customer receipts, or eyewitness testimony of cash transactions, the court lacked the clear and convincing evidence standard typically applied when deviating from reported income under Texas Family Code, Section 154066B. The judge's questioning about eyewitness knowledge directly tested whether Ms. Holton could meet this burden. This exchange illustrates a fundamental trap for self-represented litigants, the belief that information suggesting wrongdoing automatically becomes courtroom proof. Courts cannot act on suspicion alone, and the failure to understand evidentiary standards often leaves valid concerns unaddressed, potentially allowing support obligations to be set below what a parent can truly afford.
Well, again, I know you think that's evidence, but it can be, it may not be. But I got a quick question to the state. As far as current child, are we under the temporary order? Oh, I'm sorry, are we under a temporary order that has reduced the child support to down to 204, Mr. Coates? Or are we still at the prior order 304 on the child support?
This would be a final, and just given a little bit based on the testimony that was presented at the last hearing, there was at least an argument that his condition would at least exist for the foreseeable future. So the state's position is just that it would make more sense to do it as a final. There was no pending indications that there would be an upgrade in his condition in the next, near future.
All right, ma'am. Now, ma'am, do you have any eyewitness knowledge or eyewitness information showing that you've seen the father out working or earning funds? Again, stuff on the internet can be fake. It doesn't mean it's true and correct, but it doesn't show what his actual earnings are. So, do you have any eyewitness information or anything he's told you that shows that the court should just go ahead and at the minimum keep the child support currently where it is, or reduce it down by 1/3?
Any eyewitness?
Okay. What city?
Um, somewhere up there by Houston. I don't know the name of it.
All right. Does he have any specialty licenses or anything that you know that he's done as far as being able to earn funds that he's done for more than a 2-year period? Like, was he a carpenter for 2 years? Was he a bricklayer for 2 years? Anything like that?
As far as certifications,
Just for the court's knowledge, Judge, he did report a $1,600 monthly gross wage.
of course he did.
Don't make comments behind it. All right. And how many other are we looking at? One child in? How many out?
These are a total of 3 kids. I think this is the only child that would be under it. I believe there are 2 other children in NCP's household, Judge.
All right, so the 1,600 is just about right around or just above minimum wage. So at 20%, instead of 204, you'd be closer to 240, correct?
Yes, Your Honor. The percentage, just so you know, that was in the order was 16%.
Okay, so there are 2 other.
Your Honor, I'm not certain about the
Yes,
age.
they are.
All right then. All right, ma'am. Again, if they were over the age of 18, I could do something about it. I was going to go ahead and change things around, but right now I don't see anything that I can do differently other than the fact, again, because there's no conclusive evidence. Evidence that is at least preponderance of the evidence of clear convincing that the gentleman is doing more than he alleges he's doing, as far as being able to earn funds. So I'm looking to go ahead and order current child support at 204. I'm not going to start that amount. I'm not going to go back to the date of service, Mr. Coach. I'm going to go ahead and order that to start the first day of April, since the first day of the March is almost here. So I'll modify the child support to start the first day of April. Otherwise, it remains as is until then.
Is it 204 or 206?
Wait, I'm
206.
sorry. 206? All right, 206, ma'am. Sorry.
Your Honor, I'm sorry. Can you check your docket sheet from
All right, okay. I'm sorry. I was looking at the last one back in April, and I'm sorry, in November. So we did something on 10/8.
Judge, yeah, we started in this order, the new support obligations, at least in the order that's been drafted at November 1 of 25.
All right, so I see. Okay, sorry. Okay, I see 1,600 was it what he testified to? Uh, we said cash medical was 72 back then,
That
and the child support was set at.
was at 30.
Man, what kind of yeah. All right, that. And those other two children, are they in the same household or are they two separate children?
I know one lives with his mom, and then
All right, so what I'm going to go ahead and do, Mr. Coach, I'm going to go ahead and reduce the cash medical to $36 in this case, and I'm going to go ahead and transfer that extra 36 over to mom. So I'm going to raise him back up to 240. Okay.
Okay.
All right, ma'am. I'm going to move some money around, man, because the health insurance amount's a little high for three separate households. So I'm going to adjust that downward, and I'm going to give you the difference and start that the first day of March and I'll go ahead and start that the first.
The judge methodically dismantled the mother's objection by applying the appropriate legal standards, first confirming the father's reported income of $1,600 monthly fell near minimum wage, then explaining that without meeting the preponderance or clear and convincing evidence standards, he could not deviate from that reported income. The judge also adjusted the effective date rather than making the reduction retroactive. Texas Family Code Section 154509 governs the effective date of modified child support orders, providing that modifications may apply retroactively to the date of service of the petition. But only as justice and equity require, Texas courts have interpreted this discretionary language to permit judges to delay effective dates when circumstances warrant, as in Tilley v. Tilley, 927 SW2D 662, Tex. App. Houston, 14th Dist., 1996, where the court upheld a trial judge's decision to prospectively apply a modification to avoid inequitable results. Additionally, the percentage calculation referenced, 16% for one child when the obligor has other children to support, derives from Texas Family Code Section 154125, which establishes adjusted guidelines when an obligor has multiple family obligations. The judge's decision to set April 1, 2026 rather than the date of service as the effective date represented a classic application of Section 154, Monance 089's equity provision. Given that March 1 was almost here, immediate implementation would have created administrative burden with minimal financial impact. The judge's recalculation, initially confused between 20% and 16%, demonstrates how multiple child adjustments under Section 154.125 operate. With two other children in the father's household, the standard 20% for one child reduces to 16%, producing the 206-figure figure. 16% of 1,600 equals $256, though the transcript suggests further adjustments for cash medical support. Effective date decisions significantly impact arrear age calculations and enforcement actions. A retroactive modification can create immediate judgment debt. A prospective application protects obligors from sudden large obligations, but may disadvantage obligees who expected higher support. Understanding this discretionary authority helps parties negotiate realistic expectations and frame arguments about equity.
So, Judge, just so I'm clear, March 1, he will be paying 36 in cash medical, and then he will pay, what's the amount in child support?
240.
240. Okay.
Oh, I'm sorry, 242. 36 plus 30. I'm sorry, the judge is losing it. So yeah, it's 242. Sorry about that.
242. Okay. I'll redraft the order and then get it submitted to you
All right,
probably
thank you.
tomorrow.
All right, ma'am, is there anything else?
I guess not pertaining to the order, no.
All right. Thank you very much, ma'am, and we're off the record. You're free.
Thank you for your time, ma'am. Thank you, Judge.
All right, does this hold be excused or you want it back and break out?
No, we're not waiting on signatures or anything because I don't have the order finished, so.
All right,
we
ma'am.
can- Judge, I think that takes care of me for the day, so I'll get out of your way.
All right, then let me finish writing this one up because now I got to change what I wrote down. So yeah.
I get you.
All right, then. Justice, thank you very much. What do you have, sir?
I just had a quick one where I just wanted to finalize a temp order. This is one where we've been having an issue with the parties showing up.
I'm sorry. What was that? Sorry, you cracked up on me. What was that last statement?
Oh no, you're good. I was saying I have one where we've been having an issue with the party showing up, so we just wanted to finalize a temp order.
What's the cause number?
It's 269-263.
All right. Yeah, Belinda's brought that one up already. Let's see what y'all have. Either party present right now?
No, Your Honor.
All right, let me check the notice then. We'll go ahead and get started in just a moment. Thank you.
Mr. Wright. Oh,
All right, then. Looks like we're getting started in just a second.
The court entered a modified child support order effective March 1, 2026, setting the father's monthly obligation at $242, comprising $206 in base child support and $36 in cash medical support. This represented a reduction from the previous $304 monthly obligation based on the father's reported $1,600 gross monthly income following his workplace injury. The mother's objection based on alleged unreported carpentry income was overruled for insufficient evidence. Notably, the judge adjusted the cash medical support downward from $72 to $36 and reallocated the difference to increase the base support amount, a technical modification to account for 3 separate insurance households. The order was to be redrafted by the state representative and submitted for the judge's signature the following day. This case exemplifies the critical distinction between information and evidence that pervades all legal proceedings, but particularly affects self-represented parties in family court. Ms. Holton possessed what she reasonably believed was proof of underreported income, photographs of work product, social media posts with pricing information, and personal knowledge of her ex-partner's capabilities, yet none of this satisfied the evidentiary thresholds that courts must apply. The Texas rules of evidence require authentication, relevance, and reliability. While substantive law under Family Code Section 154066 demands concrete proof of actual earnings or deliberate income suppression, not merely capacity to earn or suspicion of unreported work. The judge's patient but firm response, placing the mother under oath, testing her knowledge against legal standards, and ultimately explaining why her evidence failed, illustrates the access to justice gap that occurs when parties lack legal representation. A represented party might have subpoenaed bank records, deposed customers, or hired a forensic accountant to trace cash transactions. The unrepresented party instead brought photographs to a hearing requiring financial documentation. For viewers, this case underscores 3 essential lessons. First, courts cannot act on what they suspect, but can only decide based on what is proven. Second, the burden of proving intentional underemployment rests squarely on the party challenging reported income. And third, procedural rules about evidence exist not to obstruct justice, but to ensure decisions rest on reliable foundations. When parties understand these frameworks, they can better prepare their cases or recognize when professional assistance is essential to achieving a just outcome. If you're facing a child support modification or enforcement proceeding, remember that preparation matters more than passion. Document actual income through bank statements, tax returns, and business records, not photographs or social media posts. If you believe the other parent is hiding income, consult with a family law attorney about subpoena power, depositions, and forensic accounting. Many jurisdictions offer self-help resources through court websites and legal aid organizations that explain evidentiary requirements. Understanding what courts can actually consider and building your case accordingly transforms valid concerns into winning arguments.